2026, the matter of the state versus Reiger Park. Accused 1, accused number 2, Jamal Meyers, and accused number 3, Alvino Livet Crawford. Today being the 25th day of August 2026, court sitting at Reiger Park before the Honorable Manana, Mr. Manana, Public Prosecutor, Advocate Ramtapedi, and the Interpreter, Ms. Falani, and for the defense, Mr. Kuzani. The matter has been duly set down today for purposes of bail application. Boxback, sorry, Worship. I'm indebted, Worship.
Confirm you are again chased the police. Language difference. Jamal Meyers. Language difference. Alvino Livet Crawford. Language difference. Mr. Kozani, do you confirm that you are attending for all three accused?
Correct, Sir, Your Worship. I am on behalf of all the three accused before this honorable court, and we are ready, Your Worship, to proceed with the bail application. But, Your Worship, I will have one request before I start, if I may just approach my clients. God please. Your Worship, I just want to clarify something from my clients. My clients opt to proceed in Afrikaans, all three of them. Yes, Your Worship, that is something that I wanted to clarify with them, Your Worship, because I've heard one of them says in English. So he's saying that you'll proceed in Afrikaans rather. So all three of them, they will proceed in Afrikaans.
Right, before we commence counsel, for the benefit of the members of the public and also the media houses, Mr. Kuzani, one of the accused, is standing before court there in the bail application, specifically accusing. Do you have any objection if we proceed with this application?
Your Worship, my answer to that is I have no objection. And I will allude why I don't have an objection. The first reason is largely because the court dealt with the bail application of accused number 1 in a matter that it's a C court matter, not an A court matter. As far as I understand that matter, Your Worship, it is not an A court matter in which this court usually preside over. So I honestly have no objection whatsoever. And I must say it's something that I had actually thought of to do a recusal application, but we don't have grounds, Your Worship, where we would say he will suffer prejudice or whatever reasons, honestly. So in simplicity, we don't have an objection. And that is all, Your Worship.
Counsel, any input?
Your Worship, I have gone through the record of the previous matter that Your Worship is alluding to. I don't see anywhere where the merits of a case were actually discussed. Unless there was an issue of serious conflict, which I don't see in this instance, Your Worship. And we don't have an objection if we were to proceed with this bail application.
And Your Worship, if I might as well add something, if the court allows me. Your Worship, there is no causal link between this matter and the matter that was dealt by the court, which it's a secret matter. There is no nexus at all. So I don't see any prejudice that will spring out as a result of the court presiding over this matter.
Just to briefly comment, indeed I've dealt with bail application in respect of applicant number 1, who is accused number 1 in this matter. That was in relation to another case or a different case where there was a different charge. Furthermore, in that application, accused number 1 proceeded by way of an affidavit. Therefore, no credibility finding that I could have made in an affidavit. Considering that there is no objection between the state and the defense, I will assume that we should proceed with this bail application.
Is the court resolution?
In fact, Mr. Kuzani,
Court business.
do you concede that this matter results within the ambit of Schedule 6 in respect of the application?
I concede, Your Worship, yes.
Is the defense ready?
Your Worship, the defense is ready to proceed.
Right, gentlemen, you may be seated.
Your Worship, I seek the court leave to read the affidavit in support of bail application of applicant number 1, accused number 1.
Proceed.
I, the undersigned, Collis Regan Chesley, do hereby make oath and state. I'm the applicant in this bail application. The facts in this affidavit fall within my personal knowledge unless stated otherwise and are true and correct. Any legal submissions I make, I do act on the advice of my legal representative, which advice I accept. I am advised that this honorable court has a jurisdiction to hear this matter as this alleged incident preferred against me as indicated in the charge sheet took place within the territorial jurisdiction of this honorable court. This affidavit is in support of my request for this honorable court to release me on bail pending the finalization of the matter. My date of birth is 3rd January 2003. I possess South African identity document with the following ID number: 030103543181. I do not have family outside the Republic of South Africa. My residential address is 287A, Reiger Street, Reiger Park, Boksburg, Gauteng Province. I reside in this address with my mother, my grandmother, and siblings. I'm not married. I have a 5-month-old child. I'm currently unemployed. I only passed grade 9. I have no other qualifications. I'm charged with 8 counts of murder and 2 counts of robbery with aggravating. My apologies, Worship. May I please approach that, please? My apologies, Worship, if I may proceed, read.
Yes.
I'm charged with 4 counts of murder and 2 counts of robbery with aggravating circumstances and being in contravention of Firearms Act. I understand the charges preferred against me as explained by my attorney that the charges fall under Schedule 6 of the Criminal Procedure Act 51 of 1977 and that within the ambit of the Criminal Procedure Act, I have a legal duty to prove that interest of justice and exceptional circumstances permit my release on bail. I know and understand these provisional charges. The state may add or withdraw other charges. I've been informed by my attorney of the consequences or sanction of not disclosing any previous convictions or pending cases against me. Fully understand and wish to state the following. I have no previous convictions against me. I have the following criminal pending cases against me. A murder case in Boksburg Magistrate Court in C Court. 2 counts of attempted murder in Boksburg Regional Court 1. 2 counts of robbery in Boksburg Regional Court 1. All the aforesaid cases are currently at trial stage, and in all of them I was released on bail. Furthermore, some charges were withdrawn by the state. I further disclose I have no protection order against me, and I was never released on parole. I've been informed of my right to remain silent, and that anything I say in my bail application may be used against me in my trial. I intend to plead not guilty to the charges. I'm of the view that interest of justice permit my release on bail because of the following reasons. I will comply with the provision of Section 6 subsection 4, paragraph A to E. I will not endanger the safety of the public or any particular person or commit Schedule 1 offenses while on bail. I have no resentment against the complainants or any person in this matter. I will not attempt to evade my trial. I have a valid positive address. I will comply with bail conditions which may be imposed by this honorable court. I have pending criminal cases and have never tried to run away from these cases. One of the bail conditions is to report to the police station, and I complied with all of this. I will not attempt to evade my trial or intimidate witnesses or conceal or destroy the evidence. I'm not familiar with the evidence which the state may bring and use. The court may make bail conditions which prohibits any communication between me and state witnesses. I don't have any access to evidential material in respect of these matters. No state witness came forward and claimed I intimidated them in the cases that are pending. My bail was never cancelled due to me disregarding the bail conditions. I will not undermine, or jeopardize the objectives of the proper functioning of the criminal justice system, including the bail system, or disturb the public order or undermine the public peace or security. Paragraph 9, which is the gist of our exceptional circumstances. Exceptional circumstances. I was home with my friends. We were having food sitting outside the house, but inside the yard. I have a defense of alibi, and this makes the state case very weak against me. The state case is weak in that it is practically impossible for me to kill 2 well-trained police officers and 2 females. I have a video footage that shows I was home. The video footage that I have, I'm not participating in any commission of the offense. I will present the 3 video footage in court. On the first video footage, I'm wearing a white hat, maroon jersey, and brown takis or shoes. This description is on camera 3. I'm not in possession of any firearm or dangerous weapon. I wish to present and illustrate this outfit in court. However, the police took out the outfit. On camera 1, I went out to try and help the people who were shot inside the Polo Vivo. Still at this moment, I have no firearm in my possession. The motor vehicle in which the 2 women were driving in was rolling. I had to assist them. In all honesty, I had not shot them. If I may reread your ship, what I've just read. In all honesty, if I had shot them, I would not see the need to help them. Later, at 1908, the police van passes by. At that time, the police officers were already shot. I have more than 4 witnesses. I was severely tortured by the police officers. They put a plastic over my head, said I must confess to the crime. This happened more than 3 hours. I was kept at Jimiston police station. I was laying on my stomach, tightly handcuffed. During this moment, some police officers were taking videos of me and recording me. I was sure I was dying from this torture. I told the police I killed the 2 police officers. Very important news. I told the police I killed the 2 police officers and 2 women. I further told the police I did this with Yaman, which is accused number 2 in this matter. This is definitely not true. On this day, Yamal came late on the scene. He's not part of the people I was relaxing with that night. Yamal, it's actually Jamal. Jamal Mayer. I made a mistake there. There is a player called Yamal. Jamal Mayer did not kill anyone. And I said he killed largely because I was tortured. When the shooting happened, Jamal Mayer was home. He came later on the scene. I assisted the police in finding the firearms. I did so because I saw the police who took the firearms and is not arrested till today. Not even charged with accessory after the fact. I know the person because I grew up in Reiger Park and it's a small place where everybody knows each other. It will be very stupid of me to kill the police officers right in front of where I stay, knowing very well that there are cameras. I cannot regard the rule of law to that extent. I did not run from the police officers. I was the one who gave the statement. I thought I would be a witness in this case, but later the police charged me. I've been painted and described as a gangster in Reiger Park and a dangerous person. I've never been convicted by court of law in South Africa for being violent or a killer. I assisted the police officers with open heart and integrity, and not knowing that at the end, the police will charge me. There is no firearm found in my possession that was used to kill or assassinate the 2 women and the police officers. The police are acting out of desperation and have no reason of killing police officers and the 2 women. I don't know who else killed. My apologies, Bishop. On the 7th of August, 2026, I received a text via Facebook from Problem Sithole. Kindly see herein the marked annexure RR. This annexure reflects the threats which come from Problem Sithole, known as Vusi Peterson. Problem Sithole is his Facebook name or handle. I also have no objection if bail is given subject to certain conditions. I can raise an amount of 2,000 rand if I'm to be granted bail. This is the affidavit worship that has been signed by the deponent, both initialized by the deponent and the Commission of Oath, and properly commissioned by the Commission of Oath worship, and I seek the court leave to submit it in court. Court please.
Stand up, Mr. Collis. Do you confirm the contents of this affidavit read into record by your attorney? Confirm that you signed this affidavit as a deponent. Affidavit in support of bail application in respect of the first applicant, Collins Reiger Park, is accepted and marked Exhibit A. Mr. Kuzan.
Your worship, as I've previously indicated, that all my clients speak Afrikaans. and we do have an interpretation.
So you want me to start afresh?
No, Your Worship, I'm not saying that, Your Worship. I was just reminding the
As
court.
I was saying, you responded in English.
Court business, Your Worship. No, it's something that I just wanted my clients to remember, that they said they will proceed in Afrikaans.
Yes, Mr. Kuzani.
Your Worship, I will request to proceed
Is
to...
that the application in respect of the first applicant?
That is the application, Your Worship.
Yes.
Your Worship, I seek the court leave again to read the affidavit of the second applicant.
Yes.
Court business. Affidavit in support of bail application. I, the undersigned Jamal Dezel, Mayor, do hereby make oath and state I'm the applicant in this bail application. The facts in this affidavit fall within my personal knowledge unless stated otherwise are true and correct. Any legal submissions I make, I do act on the advice of my legal representative, which advice I accept. I'm advised that this honorable court has the jurisdiction to hear this matter, as this alleged incident preferred against me as indicated in the charge sheet took place within the jurisdiction of this honorable court. This affidavit is in support of my request for this honorable court to release me on bail, pending the finalization of my matter. My date of birth is 1st August 2001. I possess a South African ID document with the following ID number 010823559608. I don't have family outside the Republic of South Africa. My residential address is 245 Rata Street, Reiger Park, Boksburg, Gauteng Province. I will reside in this address with my siblings. I'm not married, I have no children. However, I'm currently looking after my 3 siblings. All of them are minor children. My parents passed away. I'm currently doing and surviving through piece jobs such as doing gardening and selling on the street, and sell on the street. I only passed grade 7 and I have the following, and I have no other qualifications. I'm charged with 4 counts of murder and 1 count of attempted murder and 2 counts of robbery with aggravating circumstances and being in unlawful possession of firearm and ammunition and accessory after the facts. I understand the charges preferred against me, as explained by my attorney, that the charge fall under Schedule 6 of the Criminal Procedure Act 51 of 1977, and that within the ambit of the Criminal Procedure Act I have a legal duty to prove that interest of justice and exceptional circumstances permit my release on bail. I know and understand these provisional charges, and the state may add or withdraw the charges. I've been informed by my attorney of the consequences of sanction of not disclosing any previous conviction or pending cases against me. Fully understand and wish to state the following: I have no previous convictions against me. I have no criminal pending cases against me. I further disclose I have no protection order against me. I was never released on parole. I've been informed of my rights to remain silent and that anything I say in my bail application may be used against me. I intend to plead not guilty to the charge. I'm of the view that interest of justice permit my release on bail because of the following reason. I will comply with the provision of Section 60, subsection 4, paragraph A to E. I will not endanger the safety of the public or any person or commit Schedule 1 offences. I have no resentment against the complainant or any person in this matter. I will not attempt to evade my trial. I have a valid positive address. I will comply with bail conditions which may be imposed by this honorable court. I will not attempt to intimidate, to influence or intimidate witnesses or to conceal or destroy evidence. I'm not familiar with the evidence which the state may bring or use. The court may make bail condition which prohibits any communication between me and state witness, and I don't have access to any evidential material in this matter. I will not undermine or jeopardize the objectives of the proper functioning of the criminal justice system, including the bail system, or disturb the public order or undermine the public peace or security. Paragraph 9, exceptional circumstances. Regan Collis mentioned my name because he was tortured, and he further say I did not commit any crime. I'm not in a video footage which will be represented in court. I came to the scene after the incident. The police never found any firearm in my possession. I was not caught on the scene participating in committing the offense. The fact that the state charges me with accessory after the facts, this confirms my absence from the crime. The state case is weak against me. I'm associated with these charges because of doctrine of common purpose, which does not make sense because there is no active participation and association in the crime. I was assaulted by the police and I've received medical aid in Boxburg prison facilities. I also have no objection if bail is given subject to certain condition. I can raise an amount of 2,000 if I'm to be granted bail. It has been signed, this affidavit, Your Worship, by applicant number 2, the deponent, both initialized by the applicant and the commission of oath and commission, Your Worship, and I seek the court leave to submit to the court.
Does the notary wish the contents of the affidavit to be interpreted in advance?
Yes, Your Worship. Or rather, Your Worship, if I may approach my client and confirm,
Yes.
because it
Good.
seems. Yes. English is fine, Your Worship.
Do you stand up, Mr.
Yeah, ma'am.
Mayor? You confirm that do you confirm the contents of the affidavit read into record on your behalf by your attorney? Further confirm that you have signed this affidavit as a deponent. Affidavit in respect of applicant number 2, Yamal Denzel Mayor, accepted and marked Exhibit B into record. Mr. Kuzama.
That is the second applicant's case, Your Worship.
Yes.
If I may read the affidavit in respect of third applicant.
Proceed.
Affidavit in support of bail application, I, the undersigned Elvino Levet Crawford, do hereby make oath and state. I'm the applicant in this bail application. The facts in this affidavit fall within my personal knowledge and unless stated otherwise are true and correct. Any legal submissions I make, I do act on the advice of my legal representative, which advice I accept. I'm advised that this court has a jurisdiction to hear this matter as this alleged incident preferred against me. As indicated in the charge, took place within the territorial jurisdiction of this honorable court. This affidavit is in support of my request for this honorable court to release me on bail, pending the finalization of my matter. The date of birth is 10 April 1999. I possess South African identity document with the following ID number 9904 1051378081. I don't have family outside the Republic of South Africa. My residential address is 271A Louisburg Street, Reiger Park, Boxburg, Gauteng Province. I will reside in this address with my mother and siblings. I'm not married. I have one child. I'm currently unemployed. I only passed grade 11. I have no other qualification. I'm charged with 4 counts of murder, 1 attempted murder, and 2 counts of robbery with aggravating circumstances, and being in unlawful possession of a firearm and ammunition. And as I saw after the facts, I understand the charges preferred against me is explained by my attorney that the charge fall under Schedule 6 of the Criminal Procedure Act 51 of 1977, and that within the ambit of the Criminal Procedure Act, I have a legal duty to prove that interest of justice in exceptional circumstances permit my release on bail. I know and understand these are provisional charges. The state may add or withdraw the charges. I've been informed by my attorney of the consequences of sanction of not disclosing any previous conviction or pending cases against me. I fully understand and wish to state the following. I have no previous convictions against me. I have no criminal pending cases against me. Further disclosed, I have no protection order against me. I was never released on parole. I've been informed of my right to remain silent and that anything I say in my bail application may be used in my trial. I intend to plead not guilty to the charge. I'm of the view that interest of justice permit my release on bail because of the following reasons. I will comply with the provision of Section 6, subsection 4, paragraph A to E. I will not endanger the safety of the public or undermine or not endanger the safety of the public or any person or commit Schedule 1 offenses. I have no resentment against the complainant or any person. I have a valid positive address. I will comply with bail condition which may be imposed by this honorable court. I will not attempt to influence or intimidate witnesses or to conceal or destroy evidence. I'm not familiar with the evidence which the state may bring or use. The court may make bail condition which prohibits any communication between me and the state. I don't have any access to evidential material in respect of this case. I will not jeopardize or undermine the objectives and the proper functioning of the criminal justice system, including the bail system, or disturb the public order or undermine the public peace and the security. Paragraph 9, exceptional circumstances. I have a defense of alibi. During the shooting, I was home with my son and my mother. I'm incorrectly charged. My mother is my witness in this case. She will come testify before this court. I'm not in any video footage. This confirms that I was home. The police never found any firearm in my possession. I was not caught on the scene participating in committing the offense. The fact that the state charges me with accessory after the fact, this confirms my absence from the crime. The state case is weak against me. I'm associated with these charges because of the doctrine of common purpose, which does not make sense because I was home at all material times. I will also have no objection if bail is given subject to certain condition. I can raise an amount of 2,000 rand if I am to be granted bail. This affidavit worship has been signed by the deponent, also initialized by the deponent and the Commission of Oath, and properly commissioned at Boxback by the Commission of Oath worship. And I seek the court leave to submit it to the court.
Stand up, Mr. Crawford. Do you want the affidavit to be interpreted in Afrikaans?
Yes.
Court business, worship.
Hierdie is jou verklaring om voorhandsval voor die edele, né? Je ziet dat die aanvaardende werktijd is, dat die onder de eerlijke hoor die aanzoek brengt en een verklaring wat die persoonlijke omstandigheden vraagt van. Je weet dat die klagtes wat die teen vastkijk wat het is en die het recht teenwoordiger wat die ook saam met hom gepraat het in verband met die saak. Die is voor die eerlijke hoor en die klagtes wat beweer word wat die gedoen het en dit val onder onze eerlijke hoor. En die verklaring sê dat die eerlijke hoor die recht dat jy moet teruggelaat op geboord, dat die geen op eindes op boord of hangende sake of sake wat die nog nie gefinaliseer het nie. Die vertel jy of nie kennis om te sê dat die geboortedatum, dit is op die 10de April die jaar 1999, die is in besit van een Suid-Afrikaanse identifikasiedokument. Die ED-nommer is 9904155137081. Die stel jy op in kennis om te sê dat jy het nie familie buiten die Republiek van ons land hier in Suid-Afrika nie. Die stel jy op in kennis dat die woonadres, dit is nommer 271 blok A, daar in die straat in Reiger Park en hier in Boksburg in die provinsie van Gauteng. Die stel jy op in kennis dat die woon daar saam met die ma en die familielede. Die is ongetrouwd, het een kind. Op die oomblik is hy werkloos. Die hoogste graad wat hy geslaag het, was graad 11 en het geen verdere kwalifikasies wat hy besit. Die stel die hof in kennis in paragraaf 6 dat die klagtes wat hy vastkijk, dit word beweer dat dit 4 vermoord is. Daar is eentjie vir poging tot moord, daar is 2 vir roof, daar is dat hy nog eentjie wat bygevoeg het om te sê dat hy in besit van 'n vuurwapen is wat nie 'n lisensie, wat nie die lisensie vir het nie, en ammunisie, dis die klagtes wat hy teen vaskyk. Hy het saam met die prokureur gepraat in verband met hierdie borg en hulle het saamgestem dat die borgaansoek val onder skema 6 in die kriminele prosedure van artikel 51 van die jaar van 1997 van die kriminele prosedure in die artikel. Hy sê ook dat as hy in die omstandighede kan vrygelaat word op borg in die provisies wat hier is, jy weet ook nie of daar nog klagtes gaan bygevoeg word of daar nog klagtes gaan teruggetrek word. Jy vertel vir ons in paragraaf 7 dat die prokureur het vir u in kennis gestel van wat dat jy eerlik moet wees oor vorige sake, hangende sake, lasbriewe wat uitgesteek teen jou en jy sê dat jy geen vorige sake het nie, dat jy geen hangende sake het nie en jy eerlik, daar's ook die interdik wat jy teen vaskyk of dat jy uit is op parol nie. Okay, paragraaf 8. Jy die prokureur jou reg is in kennis gestel om te sê, jy het die reg om stil te bly gedurende hierdie borgaansoek, dat die stad hulle moet wys dat hulle die sterk saak teen jy het. Jy gaan nie skuldig bly in hierdie klagtes wat jy teen vaskyk nie en dat dit nie in die beste belang sal wees van jy. Ek sê verder om te sê, as jy borg kan kry, sal jy nie verdere klein sake sal skedule. Een sakietjie sal buite sal gemaak nie, die publiek sal veilig is, sal hulle nie intimideer nie, sal hulle nie pla nie. Jy vertel die hof in kennis dat jy sal ook nie weghardloop nie, beloof dat jy sal terugkom om die saak te staan en klaar te vra. 8.3. En jy sê dat jy sal nie die getuie intimideer nie, enige getuie verniel wat voor sal kom nie. Jy is ook nie bewus van die stadse getuienisse wat daar buite is nie. Jy weet nie wie hulle is nie, waar hulle bly nie, so jy stel op die om en hulle nie wat enige iets nie. Jy stel ook die hof in kennis dat jy sal nie die hof van enige reel van die hof van die kriminele systeem van uitgelaat word van die borg, sal jy my dit staan en dat die publiek sal veilig is in hierdie sekuriteit en die omstandighede. Die persoonlijke omstandighede om te sê van die rede. Jy sê dat gedurende die tyd wat die geskiedery gebeur het, dat jy by die huis, ek was by die huis, so met my seun en my ma. Okay, jy word keerlik nou gesê dat jy 'n hand hierin het. My ma is my getuie, sy sal voorop kom getuie om te sê dat ek was by die huis saam met haar. Ek is glad nie in enige van die videofotootjies wat verskyn nie. Dit wys om te sê dat ek by my huis was. Die polisie sê hy het geen vuurwapens aan my gevind nie. Ek was ook nergens gesien op die toneel gedurende die oortreding wat gebeur het en die klagtes wat voorgebring word en wat ek nou teen vaskyk van die kriminele klagtes wat ek nou van vaskyk. Die stad se sak is baie swak. Ek meen myself niks met hierdie, my hand is niks te doen met hierdie wat voorkom voor die hof nie. As paragraaf 10, as die edel die landrosteen beswaar het dat hy gaan vrygelaat word op borg nie, sal ek 'n bedrag van R2000 kan voortbring as my borg goedgekeur is en geteken saam met die prokureur en die polisie
Grafo, do you confirm the contents of the affidavit read into record on your behalf by writing?
Sê wie saam met jou.
So, you said you wanted to be interpreted in Afrikaans, now you are responding.
En hier sê wie saam met die verklaring wat die prokureur pas op rekord ingelees het. I confirm.
Confirm further that you have signed this affidavit as a deponent.
Stem jy saam dat jy dit geteken in verklaring as 'n deponent? I confirm.
Affidavit in support of bail application in respect of accused number C, Vino Bidet Comfort, accepted and marked exhibit C.
Court business, Your Worship, I would seek the court leave not to close the application in respect of the third applicant. I would like to call the mother of the applicant to confirm the alibi that you are raising on paragraph 9 of the applicant's affidavit. And further, Your Worship will also open the case to, we have 3 video footages that I would like to be played in court, which shows that accused number 3, or the third applicant, was never on the scene. And therefore, Your Worship, I did send some of the videos to my colleague, but that was on WhatsApp, Your Worship. I want to archive them on a stick and arrange with the clerks of this court that those videos be played as they raise the alibi, Your Worship.
Who is on record for the state is the Advocate Mashabela or
Ramjapedi, Your Worship, Advocate Ramjapedi. I think I did indicate there on the appearance.
there is an application by the defense for a request.
Your Worship, we've got no objection whatsoever. I think we even deal with that in our affidavit. But in as far as applicant number 3, I think my colleague is referring to applicant number 3. Yes, I'm not sure of any footage relating to applicant number 3, but whichever that may be, we are not contending that he was at the scene. I don't think it's of any assistance. We will outline how accused number 3 is linked to the offense.
Mr. Kuzani, are you starting to defense witness for applicant number 3 or with the application for video footage?
Your Worship, I would rather first just postpone it for a video footage. And Your Worship, just for the purpose of justice, I'm not going to be deep in my explanation. This video footage that I want to present before this honorable court, it's a video footage that will actually cover all the applicants before the court.
All 3.
Yes, Your Worship. Which I see it prudent that it be part and be played in these proceedings. But it's video footage, Your Worship, that I receive in a short space of time. I need to put them in a USB stick, give them to the state, and engage the clerk of the court that we be provided with material or facilities in which will play this video footage. So that is why, Your Worship, then I'm not closing the third applicant's case, requesting rather a postponement. As I've mentioned, Your Worship, that for the purposes of justice, I find it to be very prudent that those videos be played in court. And those video footage would outline what had materialized, the event of what had happened on the 7th of August, 2026. So that largely the main reason. And as far as I've been as far as I know, rather, the rules of evidence in bail proceedings are a bit relaxed. And as far as I know, bail applications are historical in nature. Meaning that, Your Worship, what do I mean by that? I mean that even if there was a hearsay evidence, it would be in bail hearing provisionally admissible, though later it might be inadmissible during the trial. So that is why, Your Worship, I am vehemently making these submissions before the court and saying and requesting, Your Worship, humble so, with due respect, that this video footage, Your Worship, will actually play a very critical, important role, particularly when we speak about justice. So, and my main concern, Your Worship, only alleging on the affidavit that there is a video footage and it is not played. It does not put my clients in a position which will be legally good, so to argue or to speak.
Counsel for the state, I understood you not to be opposing.
The video footage.
Yes.
Let me just put it clearly. Maybe my colleague will reconsider his position. regard to applicant number 3, he might be having an alibi on the day of the incident. We are not saying he was at the scene. We will outline the role he played, that is the following day. So the issue of an alibi, he might have an alibi on the 7th. We're not disputing that. It's not an issue. So I'm not sure if that will help in as far as the other accused are concerned, because the video footage that was sent to me, it's quite limited in scope. It just reflects inside the yard at a specific time. It does not show what happened entirely on the street. So we're not objecting to that. And in fact, that is what we are outlining. My colleague can confirm to that it's limited inside the yard. It does not show anything else on the street, except for just where it leads to the gate. As to the entire incident, what was we were provided with, it doesn't really help that much, if that is the video my colleague is relying upon. But with regard to applicant number 3, we don't deny that he scored an alibi on the 7th. We're not disputing that.
Yes, Mr. Kusala.
Your Worship, there is something that is very important for the state to note. All the accused persons before this honorable court, 3 applicants, all of them, they have an alibi. All of them, they have an alibi. And the video footage, Worship, that is the only leap of faith that we have in which this can flip and be something else. So, in all these 3 accused persons, I'm raising an alibi. Applicant number 1 says in his affidavit, applicant number 2 was never at the scene. He came later. Applicant number 2 confirms, I was not there. I came later. Applicant number 3, he's saying, I was never there at all. I didn't come there. I was never there. So, now if we are saying we have a video footage, this video footage, Your Worship, will cover everything and cover even the points of factors that are not even disputed by the state. After all, Your Worship, as much as the state is not saying they are not disputing the alibi, but the video footage will actually help the court. Let's have it play, Your Worship. Hence my point of departure when I argued here, Your Worship. I said, in bail proceedings, the law of evidence is a bit relaxed because bail is inquisitorial in nature. And I've made an example about the hearsay. So, I am appealing before this honorable court that the video footage, as much as my colleague said he saw it, be played before the court. Be played before the court, and I critical explain it before the court, what transpired. And Your Worship, as much as the state does not see much of relevance of the video footage, but that video footage is very, very pertinent, particularly in respect of all the 3 accused persons. Whether it shows what is inside the yard, doesn't show what is outside the yard, it matters not. Let's have it played. Let's have the court making a decision. Hence, Your Worship has said, when we speak of justice, my client ought to be afforded that opportunity. Because the worst thing, Your Worship, here is the defense, the applicant saying, we have a video footage, it is not paid by the court. That is not justice. That will be totally travesty of justice, honestly. We have a video footage, and in all the affidavit, they are mentioned. So, let's have the video footage played. And that is actually, Your Worship, for the purpose of fairness. Whatever decision that may be made by the court, but there must at least, my client, be at ease to say that the evidence that we had, we had produced it to the court, it was presented, and the video footage was played. That is my argument, Your Worship.
Let us then focus on the legal requirements of a CCTV footage.
Yes, Your Worship.
And I'm going to list to you one by one,
Yes.
and then engage me. Lawful acquisition.
Court business. Unlawful acquisition, Your Worship.
Lawful acquisition.
Court business.
Relevance.
Yes, Your Worship.
Authenticity.
Yes.
Privacy consideration. And data retention.
Data
Retention.
retention. Court business.
Does the video you intend to use as evidence comply with all those requirements?
The answer is simple, Your Worship. The answer is simple, and the answer is yes and no. And I will elaborate why I'm saying yes and why I'm saying no.
Let's start with a yes.
Get. Your Worship, the video footage that I'm speaking about, it's a video footage that comes from the house of applicant number 1. There are cameras placed outside the yard and inside the yard. And that, I believe, it addressed the issue of lawful acquisition, but though not adequate. And moving to relevancy. It's relevant, Your Worship, because we are saying that video footage is the video footage that shows that my clients, at the time in which the incident happened, on the 7th of August 2026, they were at home. That is why it's relevant. So, and it's relevant in the sense that you might be having wrong people before this honorable court, and the real culprit is still looming and running loose outside this honorable court. That is why. So, that is how it's relevant. And your Worship, actually this issue of relevance, there is what we call in law the scale of justice, which has Lady Justice blindfolded. I'm speaking about the scale of justice. That scale of justice has the Lady Justice blindfolded. That scale is not part of our law for decoration. It's there for the court to practically apply it. So, and the reason why I'm raising the scale of justice, the scale of justice, the shape must be balanced. And it might be otherwise. But it's important that the scale of justice is balanced. And there is a reason why Lady Justice is blindfolded. So, my point about this, Your Worship, when we look at the scale of justice, would, in the event that the video footage is not presented before the court, will the scale of justice be in our client's favor, the 3 applicants? No. And if those video footage are provided before the court, is there nothing that will be prejudicial to the state? The answer is no. So why not play the video footage before the court? So that is why I'm mentioning the scale of justice, which has the Lady Justice. And going to the third point, Worship, which is the originality of the video footage, which is something that is very important in law. Your Worship, I have argued that during bail proceedings or hearing, the law of evidence is a bit relaxed because bail application is inquisitorial in nature. it's open, in other words, the issue of originality. And the court went further to speak about, or rather to answer it. We will not argue further about the originality of the video footage. But as I've said, it is the video footage that comes from the house of the first applicant. And that is actually his best defense, that video footage. So, and it's maybe the court might be concerned that because of the originality, this video footage it's here to manipulate everything. Let's have it played, and later the expert will be called and make a report about it. It's better in that way. And there is an issue of privacy that the court wants me to address. Your Worship, if I understood the court question in respect of this fourth point, this matter is no longer a matter of privacy. It's no longer. Absolutely. This matter is being watched in all 9 provinces in South Africa. It's no longer a matter of privacy. I try to argue that as per our constitution. So I found the issue of privacy to be not pertinent at all. It's already, it's a public matter, it's of public interest. We have people chanting outside the court, sloganeers, chanters outside the court. It's no longer a privacy matter, if I understood the court. And the last question, which is data retention. Your Worship, this goes back to what I've said, submitted before the court. And actually, Your Worship, there is a section in law of evidence that deals with data message. That deals with data message. I will not get into deep in that issue. But one thing that I will say before the court, my submissions, is that the consent of the court is very valid in respect of that. But as I've said, the law of evidence during bail application are relaxed. So that will be my reply before the court.
I've understood counsel for the state to be saying the video footage relates to the house and inside the yard.
Yes.
Does it directly relate to the case at hand? Does it clearly shows the events as proving or disproving? Does the video footage go in so far as to the point where the alleged incident of shooting occurred?
Your Worship, yes.
It does.
It does. Because there is a video footage which they're inside. While inside, they hear the gunshot. They run outside. When they get outside, there is a Polo Vivo parked outside, literally in front of the house, captured by the camera, where the shooter literally pulled the trigger on the 4 people, on the 2 people that died on the Polo Vivo. But I must be honest, Your Worship, with the court, that in respect of the 2 police officers, on the video which I've got, we just see the police van passing at that time. But my client says, applicant number 1, at that time as he was there, the police officers were already shot. Not sure whether they were killed, but they were already shot. That is what he's saying. So, that is why, Your Worship, I'm saying, if it's played in court, it's played in court, it will make a difference. And not a difference that will be prudential to anyone, but to every everyone that is involved and actually assisting the court as well. Hence, Your Worship, I'm making that request.
Thank you, Mr. President.
God bless you.
Council.
I think we all should be mindful that this is not a trial court. This is a bail court. I don't even think it's necessary to go to that extent. A video footage is part one of the considerations that the court can take into account. Like I said, the video footage was sent to us yesterday. I viewed it. It doesn't take anything any further. So, having to go like the trial route of having to authenticate, calling expert and everything, including bail proceedings, I don't think it really helps. If there is such evidence, it can be reserved and used for trial purposes. Whether it will exonerate or implicate the accused is another matter. We have specific reference to appellant number 3. We are saying we don't have any issue with his alibi. He's got an alibi or he doesn't have what the 70 years. But our evidence relate to his actions thereafter. So the application is before the court for the court to make a ruling, Your Worship, but this is a bail application. It's not a trial.
For the sake of the interest of justice, application by the defense is granted.
Court business.
Date.
Your Worship, I'm not sure whether, because to avoid any further delay, whether we should present our case and then he will take an advantage to have his right of rebuttal of whatever he might not be having. Before
Mr. Kozale, considering that you haven't closed your case,
Yes.
any issues if the respondent proceed with their case?
No, Your Worship. In all honesty, no. As long there is time, Your Worship, to do so, I have no objection, Your Worship.
Counsel.
we won't even have an objection when it comes to reopen his case and present this video.
Yeah.
It's
agreed.
It's an inquiry.
Court business, Your Worship.
Please. May we proceed with the respondent's case?
Yes.
Please, the court. I'll be presenting it via an affidavit of the investigating officer, and it does. 3 affidavits have been prepared, Your Worship, with specific reference to each and every accused. The first one with reference to accused number 1 reads thus. I, Caesar Sibeko, state under oath in English that I'm a police officer at the South African Police Service stationed at Germiston, Serious Organized Crime, the DPCI, formerly known as the Hawks. I'm currently based at Germiston 165 Mayor Street, Mockers Building, 12th floor, office number 1209, with the following contact numbers. They are listed therein. I have been appointed as a member of the South African Police in terms of Section 30 of the South African Police Act, 68 of 1995, and hold the rank of Detective Captain, with force number is listed therein. I am currently the supervisor of the Serious and Violent Crime Section. We investigate cash in transit and police killings incidents. The objectives of the South African Police Services are to prevent, combat and investigate crime, to maintain public order, to secure the inhabitants of the Republic, their property, and to uphold and to enforce the law. I perform my duties in terms of Section 13 of the same Act, read with Sections 205 of the Constitution of the Republic of South Africa, Act 108 of 1996. The facts contained herein are true to the best of my knowledge and belief. I make this statement knowing that if it's tendered in evidence, I will be liable to prosecution if I willfully stated in it anything which I know to be false or which I do not believe to be true. I am part of the investigating team of Reiger Park case 33/08 of 2026, wherein on the 7th of August 2026, the South African Police Services anti-gang unit members, Constable Tomatsan and Constable Zibeko, the 2 civilians, Jaden Magerman and Rolin Lesson, were shot and killed. I attended the crime scene and also the follow-up on the investigations. The background. On the 7th of August 2026 at about 19 hours. The two ladies stopped at Reiger Street, Reiger Park across Lakeside Supermarket. One of the ladies exited the vehicle, a red Polo. They were driving in and entered the shop. Shortly after the lady returned to the vehicle while being seated in the passenger seat, a suspect approached from the front, firing several shots at the red Polo. A patrolling police vehicle then responded to the shooting incident, and this is when the two police officers also got shot. All four died in their respective vehicles. The police officer service rifles were taken from them. The incident was recorded on a CCTV, wherein both accused 1 and 2 are seen at the scene of crime and implicated as a result, and this evidence will be properly presented in court during trial. A case docket as per Reiger Park, case 33/08 of 2026, with 4 counts of murder was opened for further investigations. The rifles were recovered at Dugatole as per Jimison case number 207/08 of 2026. Currently, the 3 suspects, or the 3 accused, are before court charged in relation thereto. The video material above corroborates a pointing out / confession by accused number 1, wherein he confesses to the killings. This also led to the discovery of the state rifles robbed from the 2 police officers at the scene. The admissibility thereof will be determined by the trial court. I am aware of the video footage doing rounds on social media platforms propagating that accused number 1 was at home during the commission of the offenses. I want to state categorically that such a video footage lacks authenticity and does not reflect what truly transpired at the scene. Information has been received as to the perpetrator who is trying to defeat the cause of justice by posting such videos to cast doubt on the state's case. I also received information that the accused himself was involved in such propaganda by posting misleading material to divert attention from the real issues. He was recently found in a cell phone in the correctional facility since the last remand in this matter. We are in possession of such a cell phone impression. The matter before the court is a formal bail application, and the state is opposing bail on the following grounds. Consideration in terms of 64 sub A, whether the accused will endanger the lives of the public if released on bail. His profile has been obtained and several serious cases have been reported against his name, where he was previously arrested, and the cases shows some not finalized, and the list is as follows. We've got a Primrose case, 14907 of 2021, wherein the accused was charged with house robbery with firearms used to rob the owner of the property. Accused was part of the 3 accused in this matter. The status of the matter shows that it does not reflect any update at this stage. Sorry. Number 2, Binoni case 43607 of 2021, where the accused was charged with possession of unlicensed firearm, possession of stolen property, and the property in the Primrose case above was also recovered. They were arrested 2 hours after the Primrose incident. The same 3 accused as in the Primrose case are charged together with the accused before court. The status of this case is that it has been booked. The SPP is on the SPP's desk as we speak. Reiger Park, case 137 of 2023. It's an armed robbery case and common assault, wherein the complainant alleges that he was robbed of 100 rands, assaulted with a firearm, was hit on the nose and head with it, and the status of the case, it's part of the cases which have been remanded to the 2nd of October 2010 in the regional court. Same goes with Reiger Park case 140-02-2023. It's an armed robbery case and assault GBH. The complainant therein alleges that the accused entered his yard, pointed a firearm at him, and robbed him of his bicycle and cash in the amount of 200 rand. And the accused then assaulted him with a firearm by hitting him in his face, mouth, and thus losing 2 upper teeth and 2 lower teeth in the process. It's one of the cases postponed to the 2nd of October in the regional court. The Reiger Park case 603 of 2023, accused charged in possession of unlicensed firearm and ammunition. And members were reacting to cases mentioned in paragraph 3 and 4 above when they arrived at the accused's place of abode, accompanied by the complainants to point out the accused who robbed them, and they pointed the accused out. The officers then asked the accused if he possesses a firearm, and he produced a firearm without a magazine and 3 live rounds, and then he was then arrested on a new case of possession of a firearm and ammunition without license. It's one of the cases postponed to the 2nd of October. Reiger Park case 10810 of 2023. This is a double murder case of Mr. Dillian Riddles and Mr. Levano Fisachi, who were shot dead. Accused was out on bail. The matter was in fact before the court rolled today, the 25th of August 2028, and it has since been postponed to the 4th of September 2026. In this case, the witnesses were threatened with death. They have since been admitted to witness protection as they fear for their lives. Reiger Park case 4011 of 2023, accused charged with attempted murder, wherein the victim was shot on the chest, on his back, but he survived the attack. The status of the case is one of the cases postponed to the 2nd of October 2026, with Boxback case number 09 of 2029. I don't know the correctness thereof. But it's one of the cases nonetheless postponed to the 2nd of October 2026 in the regional court. In this case, the accused has intimidated witnesses and threatened them with murder to an extent that they are afraid of coming to court, as confirmed by the investigating officer's statement, which is attached here too, which I'll later on hand with the affidavit. Reiger Park, case 6711 of 2023. The accused charged with attempted murder and malicious damage to property. The complainant alleged that the accused shot him in the arm and set his house alight. The status of the case is one of the cases postponed to the 2nd of October 2026 in the regional court. 2nd October 2026 is the new date. Reiger Park case 12311 of 2023. Accused is charged with murder and attempted murder. The deceased therein is Mr. Kino Bok, who was shot twice at the back of the ear and had one step wound on the chest with the knife still stuck in his body. Another person was shot in the arm and he survived. This matter was removed from the roll as both accused number 1 and number 2 in that matter were brought late to court outside the 48-hour period. The matter is ready for investigations. With the case with us now, the accused will be charged with that matter. Reiger Park case 13607-2025. Accused is a person of interest therein. It's an attempted murder wherein a complainant was shot in the left shoulder. In this matter, the investigations are continuing. And then lastly, Reiger Park case 3008 of 2026. Accused is also a person of interest in that matter. It's a murder case. The investigations are ongoing. As soon as they are finalized, the accused will be charged on that docket. Section 64 sub B, whether there is a likelihood that if accused is released on bail, will evade this trial. Yes, the accused address has been verified at number 287 Liboki Street, Reiger Park. He stays there with his mother. The accused on this matter was difficult to trace. The accused does not possess a passport. The accused has means to evade trial by running away and hide outside the province as he has family outside the province. He has access to vehicles to use, and his power with the gang is proof that he could be hidden by the people close to him. The severity of the charges he is facing will motivate him to be a flight risk as he is facing possible life imprisonment. He is a South African. His legality is not in dispute. Section 64 sub C, whether there is a likelihood that the accused, if released on bail, will interfere with witnesses. In the above mentioned cases, the victims were witnesses in one or other matter related to the accused or members of his gang. The accused himself, in his social media statement, confirmed how they shoot people and inviting his enemies to come and try shooting at them. The accused also, by means of associates and family members, can interfere with the investigations. Gangsterism works with instructions and orders given to low-ranking members to execute such. The accused himself informed members that Reiger Park will ban if something should happen to him, proving his influence and power. The state has not concluded its investigations as there are still outstanding suspects and witness statements. Section 64, sub D, whether there is a likelihood that if released on bail, the accused will jeopardize the objectives and functions of the system, including the bail system. The indications are that the accused will jeopardize the bail system as he is being released on bail and he continues committing offences whilst out on bail. His criminal history started in 2021 and has not stopped. The courts are being lambasted for granting bail, and accused continue committing similar offences, considering that all accused. We also consider that the accused has a presumption of innocence until proven guilty by a court of law. Section 60, sub 40, sub E, whether exceptional circumstances exist that the accused, if released on bail, will disturb the public order. As previously stated, the accused allegedly threatened the Reiger Park, that Reiger Park will ban if anything happened to him. It is further alleged that his gang may retaliate through revenge attacks. The accused's family has also alleged that the police are working with a rival gang and are therefore framing the accused. The Reiger Park community is seen as a second community next to Mitchell's Plain in Cape Town, which is having a high rate of weekly murders taking place. By refusing bail to the accused, it will instill order in Reiger Park and send a message to other criminals that law and order is essential for community safety. The state opposes bail on the basis that it has a strong case against all the accused. Mr. Collins is alleged to be a well-known gang member in Reiger Park who is feared by the community. He is unemployed, lives with family, and his means of financial support are unknown. His criminal history includes arrests relating to violence and firearms. The present matter is of significant public interest. 2 women were killed during Women's Month shortly before the official commemoration. And 2 police officers were also allegedly attacked and killed. The firearms used in the killings have not yet been recovered and may therefore remain capable of causing further harm. Additional cases are being reported as community members are increasingly coming forward against the gang-related violence. I believe that releasing the accused on bail may lead to renewed violence and retaliatory killings. The accused has stated that he is a member and a leader of the Veras Latos gang, which is in conflict with the so-called Sour Boys. This is consistent with allegations by his family that the police are working with the Sour Boys. The community is urged to report any official who assists gangs, as corruption cannot be tolerated. Refusing bail would also serve the accused's own safety in view of the risk of retaliation. Gang violence frequently harms innocent bystanders and makes policing more difficult because those involved operate within the broader community. The community is outraged and is baying for the accused's blood and may take the law into their own hands. This is supported by a civic organization statement attached here too. So far is the end of the affidavit. Your Worship, I'm not going to read the entirety of the statement of the community. It came to us by way of the Reiger Park Community Policing Forum. The statement was received yesterday. And just 2 important paragraphs to highlight therein. That will be paragraph 1, the impact of this case on the community. The events of the 7th of August 2026 have had a profound impact on Reiger Park and surrounding communities. The death of 2 anti-gang unit members who were responding to a violent situation, together with the death of 2 female members of the community, have created considerable fear, grief, and insecurity. These were not simply isolated incidents from the perspective of the community. They occurred against a background of serious gang-related violence and shootings that have caused residents to question whether they and their families are safe in their own neighborhoods. The community has therefore watched the subsequent criminal investigations and arrests very closely. And paragraph 2, the situation since the arrest in this matter. Since the arrest of persons allegedly connected to these events, the Community Policing Forum has observed that the serious spate of killings and related violence that has been occurring in the community has ceased. We do not place these observations before the court as proof of guilt, nor do we suggest that the absence of further incident establish the involvement of any particular accused person. We merely submit that the timing of the arrest and the subsequent improvement in the immediate security situation has provided the community with a measure of relief. That sense of relief is extremely fragile. There is a genuine concern within the community that the release of persons accused of involvement in such violent offenses could result in renewed fear, intimidation, and retaliation or violence. Lastly, Your Worship, I'll read the very last paragraph of the statement. It reads, "We do not seek vengeance, we seek justice. Due process and the protection of the innocent people. The Community Police Forum will continue encouraging residents to cooperate lawfully with the South African Police Services and other law enforcement agencies to provide information through the appropriate channels and to respect the judicial processes. We respectfully place this presentation before the Honorable Court in good faith and with the sole objective of contributing the community's legitimate safety concerns to the bail proceedings. We thank the Honorable Court for considering this presentation. It has been duly signed by the chairperson of the Reiger Park Community Policing Forum." Your Worship, lastly, I'm reading this now because they will be applicable in the other subsequent applications wherein I do not have to repeat reading say, as I will hand them all at once. This is the statement of the investigating officer in the Reiger Park case number 13702 of 2023, robbery with aggravating circumstances. Those are the list of cases I've read in the affidavit just now, Your Worship. Of importance is paragraph number 3 of the statement by Mlungisi Mabena, the investigating officer. On the 3rd of August 2026, all the above mentioned dockets were at court as the matter was set down for trial. On the day I was busy, then I asked my colleague Sergeant Mabunda to transport the following witnesses to court, as they told me that they fear for their life by going to court alone. The witnesses were Brandon Fleck, Vusi Peterson, Nathaniel Hermanus, and Andrietta Ford. Mr. Brandon Fleck was released by the court early before his testimony, as he told the court that he was not feeling well due to the injuries he sustained when he was shot at Reiger Park case. It's one of the cases I've read. Mr. Fleck is a complainant in one of the cases that I've highlighted. And he was transported by Sergeant Mabunda back to his home, as he told me that he still fears for his life. Paragraph 4. The same day at about 16 hours, I received a call from Andrietta Ford telling me that the matter has been postponed and that they are done now. They are waiting for the transport to take them back home. I informed her that they can wait as I am arranging transport to take them home. Ms. Ford called me again, saying that Mr. Regan Collins, who is the accused, is threatening to kill them. I told her that she must go to the prosecutor and inform him what Mr. Regan Collins said to them. The prosecutor called me, telling me that the witnesses are afraid of the accused, Mr. Collins, as Mr. Collins is intimidating them. I informed the prosecutor that I have arranged transport to take them home. I then received a call from the magistrate, telling me that I must get more police to escort the witnesses. I informed the magistrate that I have arranged, and I also gave him the contact number of the station commander at Reiger Park Police Station. Same day, after about 20 minutes, I received a call from Ms. Ford informing that the witnesses have arrived home safely. On the following day, at about 9 o'clock, I went to Reiger Park to look for the witnesses, and I didn't get all of them. I went to them again after Regan Collins was arrested, and I found Ms. Ford and Mr. Hermanas. They told me that Mr. Regan Collins informed them that while they were inside the court that he is going to shoot them. He's going to wait for them outside the court. I told them that we must go to the police station to open a case against him. They refused, and I asked to obtain their statement again, and they refused. They told me that even if Regan Collins is in prison, they still fear for their lives, as he is the leader of a Votos Locos gang, and some of the gang members who are outside can kill them. At this moment, it's only Mr. Brandon Fleck who provided me with the statement, as the other witnesses, Mr. Peterson, is nowhere to be found. I went to his home several times. His sisters told me that they don't know his whereabouts. It's been days since he left. Those are the statements with specific reference to the first applicant. As I said, Your Worship, the attachments will be relevant as well to the statements of the subsequent applicants.
affidavit of the investigating officer is accepted and marked Exhibit D. Annexures will be marked Annex 1 and 2 for Exhibit D.
Council, please, the question.
What is this?
Proceed, Council.
Please, the court worship. Just to place it for record purposes, the second statement in relation to applicant number 2 is similar in substance with the statement with regard to applicant number 1 up to paragraph number 7. I'm not going to repeat same for time purposes.
Up to paragraph
Number 7. Those are just formal clauses. Paragraph 7. I'll start reading from paragraph number 8. This relates to the bail application of accused number 2, Mr. Jamal Denzel Meyers, with ID number 010823559688, residing at 245 Buttercup Street, Reiger Park, who is unemployed. The state is opposing the bail application on the following grounds. Consideration in terms of section 60, sub 4, sub A. Will the accused endanger the lives of the public if released on bail? The accused profile has been obtained, and the following cases have been observed against his name. Thus, the Reiger Park case 14803-2026, accused has been charged with possession of drugs, where police did stop and search operations and found him in possession of suspected crystal meth. The status of the case shows that it is not placed on the roll for lab result. The matter will be enrolled as soon as investigations are available. This, I would like to report that this morning, I've got the docket in my possession. The lab report has been obtained. The accused will be charged on that matter. Number 2, Mondio case 1209 of 2024. This is a petty matter of being drunk in public, and it was withdrawn. Number 3, Reiger Park case 123/11 of 2023. One person got killed and the other was shot in the arm. It's been referred to in the previous affidavit as well. The witnesses informed this office that they have been threatened by the accused and they blamed for his arrest due to them having misunderstandings. This was also posted on social media and WhatsApp statuses. In this matter, he is implicated together with accused number 1. The matter was struck from the roll because the accused were brought late to court after 48 hours has elapsed. The investigations herein and finalized, the accused are to be charged very soon. Section 60 sub 4b, whether there is a likelihood that if released on bail, the accused will evade his trial. Yes, the accused's address has been verified at 245 Buttercup Street, Reiger Park. After the incident, the accused was aware that police were looking for him, but he decided to run away. Section 60 sub 4 sub c, whether there is a likelihood that the accused, if released on bail, will interfere with witnesses. Yes, there is a likelihood that the accused before court will interfere with witnesses in this case. The accused is also part of the Vatos Latos gang, and they rule by intimidation and fear. Section 60 sub 4 sub d, whether there is a likelihood that if released on bail, the accused will jeopardize the objectives and functions of the justice system, including the bail system. Here, I will state that there is no indication as to this, as this is the first real case where bail is being opposed. Section 60 sub 4 sub e, whether the exceptional circumstances which exist that if the accused is released on bail, it will disturb public peace, public order. The accused is part of the gang in Reiger Park. The accused believed that the opposing gang members gave out his hideout away, and that if released on bail, he will confront innocent people as to how it was possible for the police to find and arrest him. The police visited the address several times in search of him and could not find him. As a gang member, the accused has easy access to firearms and may again commit serious crimes. The firearms that were used in the commission of the crime have not yet been recovered. The accused profile also does not indicate that he possesses a licensed firearm. The accused also needs to be kept in custody for his own safety, as it is believed that the release of the accused can trigger revenge attacks It is also in the community's interest for him not to be released on bail. He is well known as to be part of the gang and terrorizing the community. The community is slowly coming forward, and all leads in the previous cases are being followed up and questioned to the outcome thereof. Number 9, the state opposes bail on the basis that it has a strong case against all accused. The present matter is of significant public interest. 2 women were killed during the Women's Month, shortly before the commemoration. And the firearms used herein have not yet been recovered and remain capable of causing further harm to the community. Additional cases are being reported as community members increasingly come forward against gang-related violence. This office believes that releasing the accused on bail may lead to renewed violence and retaliatory killings. The community is urged to report any police official who assists gangs, as corruption cannot be tolerated. Refusing bail would also serve the accused's own safety in view of the risk of retaliation. Gang violence frequently harms innocent bystanders and makes policing more difficult because those involved operate within the broader community. The community out there is outraged because of criminality which is perpetrated with absolute impunity, to an extent that they see our courts as recycling machines and are tempted to take the law into their own hands. Witnesses are also scared to come forward, and they believe that the law is failing them by not jailing the perpetual offenders. A report by the community is attached regarding this matter. The report has been handed in already. This is in relation to applicant number 2. I hand in the affidavit. Please, the court.
Investigating officers affidavit in respect of applicant number 2 accepted and marked exhibit E.
Please, the court. Please, the court worship. Similarly, with the affidavit relating to the first applicant, I will start reading from paragraph 8. The rest of the paragraphs are formal paragraphs and would not be repeated here. Paragraph 8, this is a matter of bail application in relation to accused number 3, Mr. Elvino Livet Crawford, with ID number 9904-1051-37081, residing at 271 capital A Lee Boki Street, Reiger Park, who is unemployed. The state opposes the application on the following grounds. Section 64, sub A, will the accused endanger the lives of the public if released on bail? The accused profile has been obtained and there are no previous cases recorded against his name. Section 60, sub 4, sub B, whether there is a likelihood that if released on bail, the accused will evade his trial. Yes, the accused's address has been verified. After the incident, the accused was aware that the police were looking for him, but he decided to run away as well. Section 60, sub 4, sub C, is there a likelihood that the accused, if released on bail, will interfere with the witnesses? Yes, there is a likelihood that the accused before court will interfere with witnesses in this matter. The accused is also part of the Vatos Latos gang and they rule by intimidation and fear. Section 60, sub 4, sub D, is there a likelihood that if released on bail, the accused will jeopardize the objectives and functions of the justice system, including the bail system? There are no indications of this, as no previous cases is recorded against him. Section 64, sub E, whether there are exceptional circumstances which exist that the accused, if released on bail, will disturb public order. The accused is part of the gang, as previously stated. The accused believes that opposing gang members gave out his hideout as well, and if released on bail, he will confront innocent people as to how it was possible for the police to find out. The police visited his address several times in search of him and could not find him. As a gang member, the accused has easy access to firearms and may again commit serious offenses. The firearms used in the commission of the crimes have not yet been traced. The accused profile also does not indicate that he possesses a licensed firearm. The accused also needs to be kept in custody for his own safety, as it is believed that the release of the accused can trigger revenge attacks. It is also in the community's interest for him not to be released on bail, as he is a well-known member of a gang and terrorizing the community. The community is slowly coming forward, and all these and previous cases are being followed up and questioned of the outcome thereof. The lengthy sentence which the accused may face if found guilty is also very important in this matter, as it may have an influence on this case and for whether the accused will stand trial or not. The state is opposing bail on the basis that it has a strong case against all accused. The merits of the case are not being discussed at this stage, as this needs to be tested in an open court. The present matter is of significant public interest. 2 women were killed during the month of women shortly before the commemoration, and 2 police officers were also shot and killed. The firearms used in the 4 killings have not yet been recovered. Additional cases are being reported as community members increasingly come forward against gang-related violence. This office believes that releasing the accused on bail may lead to renewed violence and retaliatory killings. The community is urged to report any police official who assists gangs, as corruption cannot be tolerated. Refusing bail would also serve the accused's own safety in view of the risk of retaliation. Gang violence frequently harms innocent bystanders and makes policing more difficult because those involved operate within the broader community. The last paragraph, briefly, the accused is linked through an eyewitness account that shortly after the murders were perpetrated by accused 1 and 2, together with other perpetrators who are still at large, received instructions from both accused 1 and 2 to take the rifles robbed from the police officers to a further location and ultimately at Dugatoleni Jimiston, where they were later found after a pointing out by accused number 1. The accused also made a statement corroborating this. The admissibility thereof will also be tested in the trial court. The accused was also involved in the concealment of the murder weapons. That is the statement in relation to accused number 3. Be handed in as an exhibit. Indeed, also.
Possible that we have a copy. This affidavit is not signed by the department, neither is the commission.
It's for applicant number, applicant number?
Exhibits applicant 2.
Applicant 2. It is possible it might be signed for, yeah. Here is the original, sorry for that.
Affidavit by the respondent in respect of the third applicant is accepted and marked exhibit F.
Please, the problem. At this moment, that will be the respondent's case unless the need arises for the respondent to reply at a later stage.
Respondent's case is
Please, the problem.
I got business, Bishop. Bishop, as I've previously submitted before the court that I will have a request before the court to have the matter postponed, Bishop. So I believe that the date may be arranged.
Your Worship, I think I'm engaged up until the 4th of September. If any date were to be given, let it be after the 4th of September. The 8th is also suitable. I think it's convenient for both parties to finalize the issues here.
Your Worship, may I kindly approach it? The man is raising his hand. Yes, Your Worship, the 8th of September is suitable. My client was just concerned about the Mudabi prison issue, which I believe it was resolved and ventilated previously.
So the agreed date is 8 September.
Indeed, Your Worship.
And that's in the absence of any submission or request, applicant or accused will be detained in the Oxford Correctional Center.
Your Worship, for record purposes, let me put the following. I think my colleague will also have a right of reply. As previously promised, I did promise this court that I will make a substantive application or give reasons as to why it was requested that the accused be kept at Montreal be present. Your Worship, there is a previous incident which was recorded and it circulated at large on social media platforms, wherein the accused was seen assaulting a correctional officer at Boksburg prison. The accused is well known there, and as I alluded earlier, for his own safety, that he be taken to Montreal. Now, I'm a bit disappointed because I thought that will serve the safety of the accused, but I'm disappointed in the fact that despite him being sent to Montreal prison, he was also found with illicit cell phone in the cells. It's not hearsay, it's a matter of fact. There are witness statements being collected from the correctional officers. Be that as it may, Your Worship, we submit that that is reason enough for the accused to be taken again for his own safety to Montreal prison. Please.
May I kindly approach, Your Worship?
Yes.
May I please approach my colleague, Your Worship? Stay.
Sorry, my mistake. I said a correctional officer, but apparently a fellow prisoner at Boksburg prison. Yes.
God bless Your Worship. Your Worship, in response, and I had to consult the state about this in respect of the correctional officer, Your Worship, because I had to approach my client in respect of this. Your Worship, my client disputes what is being said by the state that he once assaulted a fellow prisoner, and he is of the belief that if it was indeed so, he would have suffered legal repercussions. You cannot just assault a fellow prisoner and then nothing happens to you. And if I've heard again my colleague saying there's a video circulating of him doing that, I mean, that itself is very questionable, because it makes one to actually ask a lot of questions who took the video. Is it a fellow prisoner or inmate, or is it the correctional officers? So it's a very confusing confusing submissions, Your Worship, to say my client assaulted a fellow prisoner. And Your Worship, I must place it on record. I am the legal practitioner, legal representative, who's representing Reiger Park in all the cases that have been mentioned in this court. To be specific, all the Boksburg criminal pending cases. I'm the attorney there. I have never received such a complaint. Be it it's a family, be it it's in court, be it it's a correctional officer, I've never. And I have went to consult in that prison. I've never had such information. So it is untrue, Your Worship. And the issue of his own safety, I don't know what will make Reiger Collis unsafe in Boksburg prison. I don't know. I don't know why his safety is questionable when we speak about Boksburg prison. We cannot say his safety is at jeopardy if there isn't something that holds waters to argue that point. So it is not correct, Worship, to say he's not safe. He's safe there in Boksburg prison. So, and replying in respect of the phone, and my colleagues said vehemently that it is a matter of fact. It is factual that he was found with a cell phone. In response to this, Your Worship, my client says the phone was not found in his possession. The phone was never found in his possession. It was found in someone else's possession in the same prison. So he's disputing that, Your Worship. And with that being said, Your Worship, I believe that the Boksburg prison is much more suitable prison to have the accused person detained there, other than the Mutabi prison. So that will be all, Your Worship. But the key part, if my client had assaulted a fellow prisoner, inmate, he would have suffered legal repercussions. And none whatsoever. He never experienced any problems or any legal repercussions. So it's my argument, Worship, is that he shall be detained in Boksburg prison. And actually that is also the instruction of my client. And furthermore, Your Worship, to this, you know, it's very worrisome, I must say it on record. It's very worrisome that a prison such as Mutabi prison, one would find a cell phone. When you go to prison, I go there to consult with my client. They do a thoroughly searching. And if you are a female, you are searched by a female because it must be thorough. So it makes me to think even further, to say how possible that a cell phone was in the cells, whereas there are correctional supervisors and officers. I went to Mutabi prison to consult. I had all my phones. I was rejected to say you can't have your phones in prison, literally. So it's a bit. It's not even a bit. It's strongly questionable. It's strongly questionable. And now my client will suffer on the basis of the security of the correctional supervisors. Because one, it's easy to create an opinion and say they are actually the one who are failing to make sure that no cell phones are in the facilities, honestly. So that is what I wanted to place on record, that as far as I know, going to consult, I myself, they do a thorough search. And if they suspect something, they actually even remove your shoes to make sure that there is nothing in yourself. You only have a pen and your papers. So it's very confusing, Your Worship. And our last request is that the accused applicant number one should rather be kept in Boksburg prison.
Response?
Yes, Your Worship, the state benefits nothing out of this. In fact, it's done for convenience and for the administration of justice. There's nothing that the state is benefiting, whether it's kept in Mutabi or in Boksburg prison. But as officers of the court, we have to put this across. Your Worship, the issue of the cell phone, it is a fact accused corroborates there was a cell phone found in the cells, though he's disputing that he's the one. So questioning the issues of corruption in South Africa is like pouring water to a duck. You can do it the whole day and never succeed. So it is possible.
Mr. Kuzani, is it possible that the accused will be physically brought to court if he is kept in Mudabi?
It is feasible, Your Worship. I've seen it happening. It's from Mudabi, Your Worship. Today he was brought. Something that I cannot argue against.
Those allegations in Boksburg,
Yes.
they might be hearsay, however they are allegations. Do you think for security reasons it's safe to keep him in Boksburg instead of Mudabi?
Your Worship is safe in Boksburg instead of Mudabi. It's safe.
Even after these allegations?
Yeah, that's the thing, Your Worship. This is the instruction of my client. Allegations remains allegations. Allegations, Your Worship, are not facts. These are simple allegations, which actually I bit confusing. So because it's him who says I should be kept in Boksburg prison, and I'm not saying it is not possible that if he's kept in Mudabi, but why should he be kept there? Why? Safety reasons, other than these allegations. Your Worship, just for the court information, for the court, and this is factual. In these pending cases, Your Worship, in this Boksburg that the accused person is facing, if I remember vividly, it took me a year to have applicant number 1 released on bail. It took me a year to have him released. And we have never had a problem. We have never. In all these cases that he is appending in this court, he did not just come out so easily. We had to fight tooth and nail, and later he was out. But he was kept in Boksburg prison. And never even one single report. And never even him came to court having some bruises on his face. Not even once. So that is why I'm saying it's something that it's allegation. It's even better if my colleague says this is from Boksburg prison, correctional supervision. This is what they are saying about the accused. That you can take. That you can take. So now it's just allegations, and we must accept allegations like that. We can't, honestly. If there was a statement written by the Boksburg prison to say Reiger and Collins Chesley did 1, 2, 3 this year, this month, this time, it's understandable. It's understandable, Worship, but on this basis, we can't agree to that. We can't. And if it's my client's instruction that says, no, I'm actually okay with Boksburg prison, it's his own life offered by the Constitution, his right to life. So if he's risking his life, so be it. That is what he's saying. That is what he's saying. And as the state argued so well that they will benefit nothing and they will lose nothing. It's just for his own safety. So why should we now insist that he must be Mudabi? It can't be. It can't be, Worship. And allegations are allegations and should not be considered as factual. So that will be my submission, Worship.
Lastly, Mr. Kuzani, we are going to conclude this matter. Was it not you who indicated that hearsay evidence in this stage of the application is provisionally admissible?
That I can explain differently. Here, we cannot be dealing with an institution, parastatal of government, institution established by the government, Boksburg prison. They are not even making a statement to these allegations. And they want us to go along with those allegations. There is no such thing in law. That is what makes it different, Your Worship. Yes, it's hearsay, but let's look at who's saying this hearsay. It's a government institution that is accountable, that must be transparent. So it can't be that it must be a hearsay, honestly. Honestly, I will make your ship hypothetically speaking an example. If the Legal Practice Council says Mr. Kuzani is barred from practicing, struck off roll, someone else comes and places that in court without the report of the LPC, it cannot be accepted, honestly, because Legal Practice Council, it's a body that is accountable and must be transparent. That is why I'm arguing this matter. So, that's another thing about the law. We can't take things at face value. We can't. Everything must be scrutinized thoroughly. So, that is why I'm arguing to say, no, the Boksburg prison was supposed to at least make a statement, say something. And we're not going to take it as it's a fact until there is a signed statement that says, yes, an incident of this nature happened. So that is the main point why I'm arguing you. No, not unless the court has questions.
No.
Court, please.
The J7 issued against accused number 1 on the 12th of August 2026 is now null and void. There are no substantive reasons justifying keeping accused number 1 in Modabi. Order in terms of 339 will not be considered by the court. He will be kept in Boksburg prison. Stand up. Case remanded until 8 September 2026 for further hearing on this bail application. You are both in custody, no bail.
Vooruit gestel vir die 8 September, julle bly in hegtenis, verder verhoor in julle word aansoek.
Dr. Joshi, just maybe the message to the court order is that what number is it? Mr. Shulwan is presiding. I don't know. Court number
Regional 1.
Regional 1? Regional 2.
Yeah.
That the court order should inquire first from regional court number 2 about case number 1. There is a matter pending for him there in regional court number 2. Before he can be removed to any correctional.
No, it's postponed.
Pardon?
Original court, actually in court.
No. It's a matter, I'm referring to the matter that was initially postponed to the 2nd of October. The matter has been brought back on the court roll for purposes of Section 68 considerations, which I did inform my colleague about earlier on in the morning. So it must be first established with Magistrate Shulwan's court first before the accused can be taken out. Accused number 1 to be specific. Please, Dr.
Your Worship, if I may approach again, see accused number 1 is raising his hand.
Then there was an issue sorted out. The issue with the regional court presiding officer.
Yeah, that has been resolved. I'm informed they're saying it should appear there after lunch.
After lunch.
Yes.
Okay, gentlemen, 8 September 2026 for further hearing in custody. Not there.
As the court closes.
8 September verder verhoor in verbod aangeteken word op hierdie oomblik in afstand.
The court still, the worship still sitting after lunch?
Yes.
There are still matters awaiting.